Welcome to this presentation on school ticketing reform, a look at Class C misdemeanor school discipline revisions made in the law effective September 1st, 2013. There were a number of changes made by the 83rd Legislature, and this presentation has been prepared by the Texas Office of Court Administration, working in conjunction with a work group organized by the Senate Jurisprudence Committee at the direction of Senator Royce West from Dallas. The presentation is intended to be delivered to individuals interested in school ticketing reform efforts or involved in dealing with school discipline issues. The 83rd Legislature in 2013 passed three bills that had a primary impact on school discipline. Those three bills were Senate Bill 393 by Senator West, Senator Hinojosa, and Senator Whitmire, and sponsored in the House by Representative Lewis and Representative Sinfronia Thompson. That bill became effective on September 1, 2013. A second bill was Senate Bill 1114 by Senator Whitmire and Senator West and sponsored in the House by Representative Herrero. It became effective on September 1, 2013. A third bill was by Representative Sylvester Turner, Representative Giddings, Representative Miles, and Representative Wu, which was House Bill 528. It was sponsored in the Senate by Senator Whitmire, and it became effective on January 1st, 2014. Senate Bill 393 contained the proposals of the Texas Judicial Council, the policy-making body of the judicial branch. This presentation attempts to reconcile all of the existing statutory language and revisions made by these three bills. The presentation does not distinguish among the bills after this slide. In recent years, the adjudication of children for fine-only misdemeanors has piqued the attention of critics and, in turn, the media. Laws passed in recent legislative sessions suggested that the criminalization of misbehavior by children should be curtailed and that the unbridled outsourcing of school discipline from the schoolhouse to the courthouse is bad public policy. The Breaking Schools Rules report issued by the Council of State Governments and Texas A&M Public Policy Research Institute in July 2011 studied nearly 1 million Texas students and followed the students between 7th and 12th grade. The report found serious future consequences and disproportionality in the school discipline system. It was with this background that the Texas Legislature and the Texas Judicial Council began to suggest reforms to the school ticketing system. There were three primary purposes of this reform effort. The first was to reduce the school-to-prison pipeline. The school-to-prison pipeline has been termed this way because there are oftentimes relationships between school discipline and future prison populations. A second purpose was to remove law enforcement from school discipline issues and allow them to focus on school safety. A third purpose was to adjust the way law enforcement and school administrators handle student misbehavior on campus to keep kids in the classroom and out of the courtroom. These bills affected four statutory codes. The first one was the Code of Criminal Procedure, the Education Code, the Family Code, and the Penal Code. Where these referenced in future slides, there is an indication of which code is impacted by the statutory changes. For the purposes of understanding the new law under Senate Bill 393, Senate Bill 1114, and House Bill 528, it is important to understand four key terms, which are defined by statute. The first of those terms is child, which is defined by the Code of Criminal Procedure, Article 45.058H, as a person who is at least 10 years of age and younger than 17 years of age, and charged with or convicted of an offense that is a justice or municipal court has jurisdiction of under Article 4.11 or 4.14 of the Code of Criminal Procedure. It should be clear that the law defines a child as an individual between the ages of 10 and 16. It does not include an individual that is 17 or 18 years of age. For purposes of ticketing in schools, a child must also be a student. A second term to define is school offense. It is a new term that needs to be defined, and it's defined in Education Code Section 37.141 as an offense committed by a child enrolled in a public school that is a Class C misdemeanor other than a traffic offense and that is committed on property under the control and jurisdiction of a school district. This is basically all Class C offenses, other than traffic offenses, committed by a 10 to 16-year-old on school property. A third term to define is citation. It is defined by the Code of Criminal Procedure, Article 14.06b, by the elements contained in what is commonly referred to as a ticket. It is written notice of the time and place a person must appear before a magistrate, the name and address of the person charged, the offense charged, and an admonishment. The fourth term to understand is a complaint. A complaint is defined by the Code of Criminal Procedure, Article 45.018, as a sworn allegation charging the accused with the commission of an offense. We will discuss a complaint in further detail in a future slide. In order to properly understand the impact of school ticketing reform efforts, it's important to understand the differences in the classes of criminal offenses. There are two classes of offenses. The first one are misdemeanors. Misdemeanors involve Class A, Class B, and Class C offenses. Class A offenses involve punishment ranges that are fines not to exceed $4,000 and/or jail not to exceed 1 year. A Class B offense involves a fine not to exceed $2,000 and/or jail not to exceed 180 days. The third offense are Class C misdemeanors, which are offenses with a punishment of a fine not to exceed $500 with no jail term. Any offense that's designated as a misdemeanor without specification as to its category are Class C misdemeanors. It is these Class C misdemeanors that are the subject of most of the school ticketing reform efforts. A second class of offense are felonies. There are 5 types of felonies in the Penal Code. The first are capital felonies. The punishment range for these felonies are death or life if it's committed by an individual who was younger than 18 years of age at the time of the offense, or life without parole if committed by an individual who was 18 years of age or older. A second category of felony is a first-degree felony. The punishment range for this offense is life or 5 to 99 years in the penitentiary and a potential of a fine up to $10,000. A third felony category are second-degree felonies. These involve punishment ranges from 2 to 20 years and a potential for a fine up to $10,000. A fourth category are third-degree felonies, where the punishment range is from 2 to 10 years and a fine up to $10,000. The last category of felonies are state jail felonies. The punishment range for these types of felonies are 180 days to 2 years and a potential for a fine up to $10,000. Any offense designated as a felony without specification as to its category are state jail felonies. Now that you have a proper understanding of the different classes of offenses, it's important to understand where the different offenses are filed and which courts have jurisdiction to hear different types of criminal cases. A district court is the general jurisdiction court in the state of Texas. District courts have original jurisdiction over felony criminal matters. Another type of court is a county court at law. These are statutorily limited jurisdiction courts that generally hear Class A and Class B misdemeanors. A county court, also sometimes referred to as a constitutional county court, are constitutionally limited in their jurisdiction as well. These courts also hear Class A and B misdemeanors. In some jurisdictions, the constitutional county court does not hear criminal matters, and instead those matters are heard by a county court at law. A fourth type of court are justice courts, sometimes referred to as justices of the peace. These are constitutionally limited in their jurisdiction as well, and they generally hear Class C misdemeanor offenses. Municipal courts also hear Class C misdemeanors and are statutorily limited in their jurisdiction. The last type of court are juvenile courts. These courts are generally at the district court, county court level, or county court, depending on the jurisdiction, and they are responsible for hearing delinquent conduct or conduct indicating a need for supervision. More description on the delinquent conduct or conduct indicating a need for supervision will be presented later. The next few slides will describe the differences in delinquent conduct, conduct indicating a need for supervision, or CHINs, and criminal offenses. We'll start with delinquent conduct. Delinquent conduct are described in Family Code Section 51.03 as a number of different types of offenses. These are generally conduct other than traffic offenses that violate the penal law of the state or of the United States and is punishable by imprisonment and or by confinement in jail. Some examples of delinquent conduct under this category are felonies and Class A and B misdemeanors. A second type of delinquent conduct is conduct that violates a lawful order of a court under circumstances that would constitute contempt of court in a JP or municipal court or a county court for conduct punishable by a fine. This is primarily referred to as contempt of a court order. A third type of delinquent conduct are DWI, flying while intoxicated, boating while intoxicated, intoxicated assault, and intoxication manslaughter. And the last type of delinquent conduct identified by the Family Code is driving under the influence of alcohol by a minor, if it is a third or subsequent offense. Delinquent conduct is prosecuted in a juvenile court, and it is not considered criminal in nature in the way it is prosecuted in these courts. Notice that delinquent conduct are offenses that, if committed by an adult, would be punishable by jail or prison time. There are a few delinquent conduct offenses that apply only to children. These offenses are not considered criminal in nature and do not carry with them all of the consequences of a criminal case. Next, we will look at Chen's offenses, or conduct indicating a need for supervision. These are offenses that would not be felonies or Class A or B misdemeanors if prosecuted otherwise. Some of these offenses are referred to as status offenses, meaning that they would not be crimes if committed by an adult. For example, runaway, failure to attend school, and the like. There are several other offenses that are designated as Chen's offenses by the Family Code. Some of the offenses that are listed in the Family Code are conduct other than a traffic offense that's a Class C misdemeanor or violates the penal ordinance of any political subdivision of this state. Also, absence of a child from school on 10 or more days or parts of days within a 6-month period in the same school year, or on 3 or more days or parts of days within a 4-week period. This is often referred to as truancy. A third type of Chen's offense, voluntary runaway. The next one, huffing of paint or glue vapors. Violation of a school district's previously communicated written student code of conduct for which the child has been expelled is also a Chen's offense. Conduct that violates a reasonable and lawful order for services from a court, prostitution, and electronic transmission of certain visual material depicting a minor, also referred to as sexting. Chen's offenses are also not treated as criminal in nature and do not carry the same consequences as a criminal offense. If a child commits an offense that is designated as a Class C misdemeanor, the case may be filed in one of two ways. The first is as a criminal offense in the justice or municipal courts. A second way is as a Chen's offense in the juvenile courts as recently described. If the case is filed in a justice or municipal court as a criminal offense, a Class C misdemeanor against a child, there are a number of consequences that may be imposed upon a child. The first is that the case is treated as a criminal case for all intents and purposes. Secondly, the case may result in a criminal conviction on the child's record. It may result in potential fines against the child or criminal court costs that may or may not be waived. For most purposes, a child in a criminal court, in a JP or municipal court facing a Class C misdemeanor charge, is treated like an adult in most respects. Many people may not know that there are two offenses that are applicable when children do not show up for school. Those are failure to attend school and truancy. Failure to attend school is described in Education Code Section 25.094. It applies to students between the ages of 12 and 18 years old, and to students who fail to attend school on 10 or more days or parts of days within a 6-month period in the same school year, or 3 or more days or parts of days within a 4-week period. Failure to attend school offenses are filed in county, justice, or municipal courts, and are Class C misdemeanors. If convicted of failure to attend school, a student has a criminal conviction on their record. Truancy, on the other hand, is described in Family Code Section 51.03, subsection B, subsection 2. This applies to students between the ages of 10 and 17 years old, and applies to students who fail to attend school on 10 or more days or parts of days within a 6-month period in the same school year, or 3 or more days or parts of days within a 4-week period. Truancy cases are filed in juvenile court. They may be transferred to the county justice or municipal courts to handle, but they are treated as Chin's offenses. If found to have engaged in the conduct of truancy, a student does not have a criminal conviction on their record. Excessive absences can be filed as either of these offenses. There are multiple behaviors that can be charged as disorderly conduct. 5 of those ways are limited to students who are 12 years of age or older. These offenses used to be limited to students above the 6th grade. The 5 offenses that can be charged as disorderly conduct include using abusive, indecent, profane, or vulgar language in a public place, making an offensive gesture of display in a public place, and the gesture tends to incite an immediate breach of the peace, creating by chemical mean a noxious, unreasonable odor in a public place, making unreasonable noise in a public place, and fighting with another in a public place. Disorderly conduct such as abuse or threats, lewd exposure, and display or discharge of a firearm remain offenses that can be charged to a student of any age that is available for criminal responsibility. There are 2 offenses where the change in the law made the offenses actually no longer offenses for certain children. Those are disruption of class and disruption of transportation. Disruption of class under Education Code Section 37.124 is no longer applicable as an offense to primary or secondary school students if the offense is committed on the school campus where they are enrolled. This offense also cannot be filed against anyone who committed the conduct before their 12th birthday. Disruption of transportation under Education Code Section 37.126 is no longer an offense if the person is a primary or secondary student. The new laws, effective September 1, 2013, affected the way that school discipline could be handled in a number of different areas. However, there were some things that are still permitted and should be made clear. First of all, ticketing for traffic offenses is still allowed. The primary focus of the changes in the law were on non-traffic Class C misdemeanor offenses. Class B offenses and above are not impacted by the changes in the law. Law enforcement and school officials still have the ability to file charges for Class C offenses. However, charges are filed through a complaint instead of a citation or ticket if the student is under 17 years of age. Tickets for students 17 and above are still permitted for most offenses. There are certain things that are not permitted under the new laws. These include issuing a citation to a student for a non-traffic Class C misdemeanor committed by a child or student on school property, criminally charging a student for disruption of class on the student's own campus, even if 17 years of age or older, criminally charging a student for disruption of transportation, even if 17 years of age or older, charging a child under 12 years of age with certain offenses of disorderly conduct, and issuing an arrest warrant for a student based on an Education Code Class C misdemeanor offense committed prior to his or her 17th birthday. As discussed on the previous slide, ticketing or issuing a citation for Class C misdemeanors that are non-traffic offenses are no longer allowed for school offenses. However, a student still may be charged through a complaint. Education Code Section 37.146 sets out the requirements of a complaint for a Class C offense committed by a child on school property. The complaint must be in writing, must include the offense report, must include a statement by the witness to the conduct, must include a statement by the victim, if any. It must be sworn to by a person who has personal knowledge of the underlying facts giving rise to probable cause to believe that an offense has been committed, and must include a statement by a school employee stating whether the child is eligible to receive special education services and the graduated sanctions imposed on the student prior to the filing of the complaint, if the school district has adopted a graduated sanctions system. A school district is not required to adopt a graduated sanctions system, but may do so. We will discuss that in further detail later in the presentation. The complaint must comply with the requirements for a criminal complaint found in the Code of Criminal Procedure, Article 45.019. Items 2, 3, and 4 on the list only apply if law enforcement is the one filing the complaint under Code of Criminal Procedure 45.058. a complaint should allege that an offense has been committed. There are several additional factors to consider in the complaint process. First of all, new laws give prosecutors discretion to allow for additional rules on how a complaint should be filed. These rules may vary by jurisdiction, so you should check with your local prosecutor for information on specific rules that prosecutors have set for filing of complaints. In addition, students who receive a complaint for a Class C misdemeanor, a non-traffic offense, may also be referred to a first offenders program prior to the filing of a complaint with the criminal or juvenile court, if such program exists. Schools and law enforcement interested in determining whether or not a first offender program exists in your jurisdiction should check with your DA and juvenile probation department for potential first offender programs. First offender programs or informal dispositions are other options other than a complaint. The alleged offense may also be disposed of through other non-court options provided by the Family Code under Section 52.03. An example of such a non-court option might be a conference with parents about the alleged offense. Another primary change in the law was to ensure that records of children charged with Class C misdemeanors are restricted from being released to the public under the new law. Records for felonies and Class A and B misdemeanors processed in the juvenile courts have already been subject to such confidentiality, and this extends now to Class C misdemeanor offenses. The law now states that criminal records of children charged with Class C misdemeanors are confidential from the time of an offense, from the time it's charged, convicted, if the individual is found guilty, if the case is dismissed, or if the child receives deferred disposition. This applies to all records and files, including those held by law enforcement and information stored by electronic means or otherwise. The information related to these children may not be disclosed to the public. It can be open to inspection by certain individuals, including a judge or court staff, criminal justice agencies for criminal justice purposes, the Department of Public Safety, an attorney for the party to the proceeding, the child defendant, or the defendant's parent, guardian, or managing conservator. Please note that this applies to all records that a school, law enforcement, prosecutor, or court may have. Please note that Education Code Section 37.142 provides a catch-all statement that if there is a conflict of law, the new complaint process described previously controls. This should be considered since there are some differences in other provisions of the law regarding complaints. The next section of this presentation will discuss several frequently asked questions regarding the changes in the new laws. Graduated sanctions have been employed by several school districts to address school discipline effectively. Graduated sanctions are not required, but may be utilized specifically by a school that commissions its own peace officers. If a school district adopts a graduated sanction system, they should exhaust their graduated sanctions prior to filing a complaint against a child or student. Some examples of graduated sanctions listed in Education Code Section 37.144 include a warning letter issued to the child or the child's parent or guardian that specifically states the child's alleged school offense and explains the consequences if the child engages in additional misconduct. A second graduated sanction example is performance of school-based community service by the child. And lastly, another example is referral of the child to counseling, school-based services, or other in-school or out-of-school services aimed at addressing the child's behavioral problems. Since a complaint must be filed with the court to process a school-based Class C misdemeanor offense, not including traffic offenses, some law enforcement and other individuals have questioned whether they must go to court to file a complaint. The statute does not require this. Instead, a complaint may be sworn before any officer authorized to administer oaths, including a judge or retired judge, a notary public, or another peace officer. In addition, it may be sworn before a municipal judge, a clerk of the court or deputy clerk, a city secretary, or a city attorney or deputy city attorney. Some law enforcement officials and school officials have heard that prosecutors can ignore complaints for school discipline. Prosecutors in Texas have significant discretion to decide when probable cause exists to file a case and whether to pursue charges in court. The new law allows prosecutors to adopt rules to require complaints filed in their jurisdiction, to have certain factors in place. Check with your local prosecutor to determine if there are rules in place in your jurisdiction. The new laws enacted some provisions regarding a child's capacity to commit offenses. Specifically, the law now states that a child between the ages of 10 and 15 is presumed incapable of committing a fine-only misdemeanor, other than a juvenile curfew violation. This does not prohibit the children from being prosecuted if they're between the ages of 10 and 15. It's not a bar to prosecution or filing of a charge. However, the prosecutor must overcome the presumption. The prosecutor must prove that the child has sufficient capacity to understand the conduct for which they are being charged. Again, this does not apply to curfew violations. A second type of capacity that was added to the Penal Code is that a child with mental illness or developmental disability who, 1, lacks the capacity to understand the proceedings, is unable to assist in their defense, or is unfit to proceed, or 2nd, lacks sufficient capacity to appreciate the wrongfulness of their own conduct or to conform to the law, may raise an issue in court regarding their capacity to be charged. This can be raised by the court, the prosecutor, the defense, or a person standing in parental relation to the defendant. If this issue is raised, the court may dismiss the complaint after notice to the state if probable cause of this mental illness or disability exists. This decision of the court may be appealed. Subsequent complaints against a child where a case has been dismissed are required to be referred to the juvenile court for further proceedings. While prosecutors have discretion to determine when they will proceed with a case or will file a case in the court, courts cannot ignore complaints that are properly filed before them. The law does give judges the ability to, and actually requirement, to dismiss a complaint of failure to attend school when that complaint is not filed in compliance with the law. In particular, the law requires that a court dismiss a failure to attend school complaint if the complaint is not filed with a statement from a student's school stating that the school applied the truancy prevention measures that must be adopted and the truancy prevention measures failed to meaningfully address the student's school attendance. They must also specify whether the student is eligible for or receives special education services in the complaint. Otherwise, the court must dismiss the complaint for failure to comply with the statute. As was previously stated in the presentation, the changes in the law do not primarily impact the way that 17 and 18-year-olds can be charged. So the question has come up about whether 17 and 18-year-old students can still be ticketed. 17 and 18-year-old students are not considered to be children under the Code of Criminal Procedure, Article 45.058H, and thus can still receive citations or tickets, regardless of whether they occur on school campuses. As a reminder, 17 and 18-year-old students may not receive citations for disruption of class if they committed the offense on their own campus or disruption of transportation under Education Code Section 37.124 and Education Code 37.126. Some law enforcement officers and school officials have asked how to address fighting on school campuses under the new law. There are various options still available to school officials and law enforcement to address fighting on school campuses. First of all, schools should try to use internal school discipline measures to address the issue. Secondly, they may use graduated sanctions. They may use informal diversions, such as the first offender program previously described. They may be able to use juvenile case manager interventions. And then ultimately, there are potential charging offenses for fighting, including mutual combat. This is not an exhaustive list, but some of the offenses may include disorderly conduct, which is a Class C misdemeanor, under Penal Code 42.01A6. They may also be charged with assault, threat, or offensive contact, a Class C offense, assault with bodily injury, a Class A offense, or aggravated assault, a second-degree felony. A child or student under 12 years of age cannot be charged with certain offenses of disorderly conduct. Some law enforcement officers and school officials have asked how they might be able to charge a student who possesses drugs under the new law. There were really no changes to the ability to charge students for drug possession under the new law. The following is a non-exhaustive list of offenses which might be used. There are several offenses of possession which are available. These may be felonies, Class A misdemeanors, Class B misdemeanors, or could potentially be Class A or B misdemeanors depending on the amount. Possession of many of these drugs within a drug-free zone, which may include a school campus, enhances the punishment by one level under the Health and Safety Code, Section 481.134. In addition to drug possession, there are still offenses available for charging a student for possession of alcohol or possession of tobacco. An example of an offense for each of these is listed on this slide. For possession of alcohol by a minor, there is a Class C misdemeanor that's still available to charge a student with possession of alcohol. There's an offense of possession, purchase, consumption, or receipt of cigarettes or tobacco products by minors, which is prohibited by Health and Safety Code Section 161.252, which is punishable by a fine not to exceed $250. There are several offenses available to school officials and law enforcement officers when students are involved in gang-related activities. First of all, Class C misdemeanor offenses, other than traffic offenses, involving gang-related offenses listed above, committed by a child enrolled in a public school and that's committed on property under the control and jurisdiction of a school district, must be filed using a complaint, not a ticket, but they still may be filed. Some of these offenses may include a disorderly conduct charge under Penal Code Section 42.01. In addition to charging a student with a Class C misdemeanor through a complaint, a school official or law enforcement may seek to have a child taken into custody under Family Code Section 52.01. This section allows a child to be taken into custody if there's probable cause to believe that the child has engaged in conduct that violates a penal law of this state or penal ordinance of any political subdivision of the state, or delinquent conduct or conduct indicating a need for supervision. If the student is 17 or 18 years of age at the time of the offense, they can be charged and arrested just as they would be if they were an adult. There are several gang-related offenses that are not Class C misdemeanors. This is not an exhaustive list, but a couple of those are exhibition of firearms, which is a third-degree felony under Education Code Section 37.125, or disruptive activities, a Class B misdemeanor under Education Code Section 37.123. This is the end of the presentation on school ticketing reform efforts. Thank you for watching.